Hi, everyone. Thank you for joining us for the Discovery to Done with Divorce Mediation presentation. Today, we are going to have one of our family law attorneys, Brian Hirsch, who is a partner at Hirsch and Ellenberger in Reston, Virginia, where he practices both as an attorney and mediation, but today he'll be speaking on the mediation role. There's so many different types of mediation and alternative dispute practices. We really wanted to use this time to educate our audience so they can learn the differences and see what is the best fit so that you can have the most successful outcome. So hi there, Brian.
Hi, how are you?
Good. So you're welcome to start sharing and you can get right into your presentation.
Sure. Hi, I'm Brian Hirsch. As Lee said, I'm a family law attorney. I've been practicing for 38 years now. And so I have a pretty strong background, or very strong background in family law, and then have been mediating for about the last 15 years. Today I want to talk about divorce mediation. I want to talk about what are the differences between mediation and litigation. I want to talk about overall the advantages of mediation. The subtitle here is gaining control over your future, and essentially that is the biggest advantage, generally speaking, to mediation as opposed to having a judge make a decision for you and your family. Mediation gives you that control over your future to make those decisions. So I want to talk first about, when we talk about mediation versus litigation, talk about what I call the lawyer's bias. And by that, I mean that lawyers have been trained in the adversarial process to go into a courtroom, to each side advocate for their clients, to try and get the best results for their clients, and then hopefully persuade a judge to make a decision in their favor, or their client's favor. And if you look at law school, and I do teach mediation over at George Mason Law School, so I'm very familiar, not only as a past student but as an adjunct professor over at Mason Law School in terms of how we teach. And our course is a little different in that we're not teaching litigation, but I will say that we're dealing with students, and I deal with third-year students that are getting ready to graduate and go out and practice. That has been their training for the last 3 years, and quite frankly, we have to do a little bit of new education for them in terms of this is if you're going to represent somebody in mediation or become a mediator, that it is not litigation, and there are a number of differences because they're trained as courtroom lawyers, even though most of them will not become courtroom lawyers. They're trained to do opening statements and to make legal arguments, to write briefs and things like that. They're also trained in what we call civil procedure, which is decide jurisdiction. In other words, can this court hear this matter and what powers do they have? The discovery process of interrogatories, which are written questions that you have to answer in writing and under oath, and produce documents and subpoena things, and motions for temporary support hearings, or if there's any kind of preservation issue, if somebody's wasting assets, things like that. There is not a big emphasis even today on alternative dispute resolution, but including mediation. But it is growing, and the students now are getting more of that than they used to. So that is the good news. And I also teach alternative dispute resolution as well over at the law school, and we're teaching them in other things like collaborative law, and which is a different type of law as well, but it's not litigation. One of the differences between mediation and litigation are the remedies. And by that is what can a court order? So the first thing is, judges are not monarchs. They don't have all the power in the world to do what they want. In family law cases, in Virginia, they get their power from the Virginia Code. And if the code does not grant them the power, they do not have it. And so there have been times years ago when I was doing more litigation where a judge would order something, and I would say, Your Honor, I understand what your ruling is, but Your Honor, you don't have the authority to do that. And it's a bit of an uncomfortable conversation to have with the judge, but we're there as advocates to advocate for our client. And you sometimes, especially with newer judges, you have to explain that I know you may have ordered that before, nobody can complain, but you're ordering it now, and we don't want that particular remedy that you think you have the power to order. The nice thing about mediation is you've got so many more available remedies to you than what a court has. It's not just what's in the Virginia code, and just because the General Assembly didn't give a particular power to a judge really is not relevant when you're in a mediation setting, because we can do for the most part what we want to do, even though the Virginia code doesn't allow for it. People agree to it, then that's what's going to govern. A lot of times you can accomplish things in mediation that you can't, as I said, in courtroom. And the examples are like family therapy. A court cannot say, I want, mom, dad, and the kids, or the two parents and the kids to go to counseling because I think this family needs counseling. In mediation, people can agree to it. Same thing with co-parenting counseling. A court cannot order co-parenting counseling where two parents are not communicating well, they're not treating each other particularly well, it's affecting the kids. They can't do that, but you can in mediation. Also in spousal support, a lot of times we come up with mediation of saying, okay, somebody has variable compensation, they have bonuses, they have restricted stock units, they have stock options, things like that, where the person who is looking to pay support may feel uncomfortable for a set dollar amount because they don't know what their bonus is going to be, or their commission, or what the stock price is on the restricted stock unit. So we can come up with a base amount and a percentage of the variable compensation that's paid to the recipient. A court cannot do that. All a court can do is say X dollars per month, and it doesn't have that flexibility and that tailoring that you would want. Also, a lot of times in mediation, if you have a child that's maybe in 10th or 11th grade and the parents are separated, but the parent living in the house wants to keep the house for the child to finish high school, you can agree to that mediation. In a courtroom, it's going to be about 3 to 6 months to either have one person buy out the other, or to list the house for sale. Another important aspect of mediation versus litigation is that litigation may or may not end the dispute. As lawyers sometimes say, litigation begets more litigation. A lot of times, when I was doing, more litigation, when we would do well, or which was often, fortunately, but when we were doing well, that if you got a really good ruling, you often hear the other person at the other counsel table saying, we have to get back in court, this isn't right, I want to file all these different motions. So it just has that reaction of, well, one person feels as though they lost, they want to get back into court, they want to even the score. The other thing is that there's a lot of what we call post-divorce issues, where somebody doesn't feel like the judge did a good job, so they're going to appeal the decision. Or somebody feels like, hey, this is so burdensome financially, I'm going to file bankruptcy. And appeals now, if you have a case and somebody doesn't do well, they don't feel like did well, they can file an appeal, and an appeal takes about 9 months to a year. So that just means there's more conflict going on. The other thing is litigation just has an aggravating effect. After you have a 2 or 3 day custody trial, what happens is that, the parents have had to sit there and listen to the other parent take the stand, say all these negative things, hear all their witnesses, say negative things about them. And then they're expected, when the case is over, if they have children, to go raise those children together. And even if they're adult children, to, try and go to special events with the kid, when everybody's together, well, it's a wedding or graduation or things like that. And they have to deal with each other. The other difference is compliance. It is just human nature that if we participate in a result or a decision, that we're more likely to comply with it versus having somebody tell us what to do. And that is what litigation is. A judge makes decisions for parties because they could not make them for themselves. And it could be that the judge sides with one side strongly and gives them what they want, or the other side, or a judge may come up with something completely different than what either party wanted. But the bottom line is that the parties have to do what the judge ordered, because it is in a court order. And if you violate a court order, you can end up with a contempt hearing, which it could be anything from, if you're on the wrong side of it, a judge could chew you out and order you to pay legal fees, or in extreme cases incarcerate. So and there's just this human nature that we don't want to be told what to do. Mediation is not, you get to do exactly what you want to do, but you participate in the outcome. One of the main catchphrases in mediation is self-determination. There is no self-determination in a courtroom, but when you mediate, there is self-determination that you're participating in the result. Probably one of the biggest differences is the cost. That a litigated case costs many, many times more than a mediated case in almost all situations. You know, a heated 2 or 3 day custody case could be anywhere between 50 and 100,000 per side. I know that sounds like a crazy number, but that's where they often end up. And whereas in mediation, it's a fraction of that cost, and it moves much faster as well, because trial date sometimes may be 9 months. In some cases, if the courts are backed up, to 12 months out. The other difference is emotional, that there's an emotional cost. It's a very different setting in litigation versus mediation. In litigation, you're in a courtroom. It's a very formal setting. There's the judge. You stand when he or she walks into the room. You stand when he or she gets up to leave. You address the court very respectfully, and it is, you know, there's a bailiff there. There's a court clerk there. There's a court reporter there. And you sit at your own table and you don't talk much. It's just going to be your lawyers advocating for you. When you take the stand, you only answer the questions that you're asked. You don't get to give a long narrative or talk to the judge. And then when the judge rules, everybody's quiet. You don't interrupt the judge. And you can ask questions about the ruling. So it's a very, very stiff setting. Contrast that with the mediation, where it's in an office, conference room, or I do a lot of times in my office. We're on a first name basis. We can talk to each other directly. We can say what's on our mind. We're not limited by questions and answers the way you are in a courtroom. And you can bring up topics that you want to bring up, and not just talk about what the lawyer who is asking you questions, you know, be confined to those topics. So it is very, very different. Also, you know, just things like dress in courtroom, you know, you're going to be dressed up. You know, you're going to not be able to take a break when you want to. The judge will tell you when you can take a break, whereas in an office, you come in, you know, it's a very casual setting. So what exactly is divorce mediation? The short answer is that it is an out-of-court process that is used to resolve family conflicts. And so even though we say divorce mediation, it can also include things like prenuptial agreements. I've mediated a number of those. It is a much nicer setting, quite frankly, to have two people who are looking to a future together to sit down with a third party to help guide them through that, as opposed to having lawyers negotiate that for them, and just do it with a series of emails or letters. So it's nicer that, you know, parties can talk to each other, generate options about what they want to do. The other is what are called reconciliation agreements, where there may have been an issue in the marriage that caused some problems, and the parties still want to continue on to see if their marriage can work, but they want certain assurances before they move in that direction. So a lot of times we'll draft reconciliation agreements where it will say, okay, this is, hopefully the parties can work out their differences, but if they can't, this is what is going to happen if they don't. We do a lot of custody agreements where the parents sit together, we come up with different options, talk out different issues. As a mediator, sometimes I'll do what I call pressure testing, which is, okay, we came up with an idea, let's run it through different scenarios to make sure that this will hold up, not only for today, but maybe to hold up, you know, we're wanting it to hold up in the future. Also, mediation, a lot of it is what we call separation and property settlement agreements, or marital settlement agreements, that have, you know, everything from spousal support, child support, custody, you know, bank accounts, retirement, taxes, life insurance, health insurance, all that stuff that's taken care of. And then finally, post-divorce matters, where the parties may have resolved different issues in mediation, but then as time goes on, there may be a change. It may be that there were 3 children that was for child support, and now there's 2, so we need to adjust it, or a custody situation may not be working out as well. It may not, we may have done it 3 or 4 years ago, and we may need to update it because things have changed. The kids are older now. One of the things that we do and we really focus on in divorce mediation is to identify what is important to the parties, to make sure that they're heard. And if something is important to a party, then it's important to the mediation process. We discuss options. There's a lot of brainstorming that goes on where sometimes people will say, I know we have this problem or this issue that we need to work out. Let's just sit here and come up with all different options and see which one feels the best and works the best, and then we'll try and draft it and make sure that it will hold up to to the actual real life situation. And this is parties determining their own outcomes. This is sitting there and coming up with solutions for your situation. What the mediator does in that is they help guide the parties through the process, where we make sure that we've identified all the issues that we need to. That is one of the mediator's job, is to say, we haven't talked about who's going to claim the kids for tax purposes, or we haven't talked about, is there any college or post-high school training that you guys want to commit to for the kids? So, to make sure that we've addressed everything, not only that what the parties bring in, but things that we know that as mediators that we need to address as well. And then one of the most important jobs for the mediator is to make sure that we draft a good agreement, that whether it's a custody agreement or prenuptial or a separation agreement or whatever it is, that it addresses all the issues, it accurately reflects the resolutions that the parties came up with, and to make sure that this is what the parties want, so that when they read it, that they understand, yes, that is what we agreed to. And the process, I'm going to talk about this a little later, is a completely voluntary process. Again, compare, contrast. Litigation is not voluntary. Somebody files for a divorce action or custody action or whatever it is, and then you're off to the races, so to speak, because you're going to get, if you did not file it, you are going to get brought through this process. So why mediate? One of the advantages to mediation is that it allows parties to work cooperatively through what can be sometimes difficult topics. Two of the most litigated issues are custody and spousal support. And a lot of that is because they're both emotionally charged issues, but they're also issues where judges have a lot of discretion. And what I mean by that is that there's a lot of different possibilities a court can come up with. When you look at property division, most of the time we can figure out what a judge is going to do and how they're going to split things. And sometimes by the Virginia Code, there's only so much they can do. So property division is not as tricky as custody is or support is. Custody and support are much more dynamic issues. And so the nice thing is, parties can sit down and work through these issues together, where maybe there's an issue of trust between the parties on a custody situation. Maybe there's an issue of alcohol or substance abuse that we need to talk about and set up some safeguards for. And how do we do that together, where we set them up where the parties feel that they can trust each other. Also, they can feel like they're working in a positive way. Spousal support can be the same way, in terms of okay, maybe we've had a stay-at-home parent who's been out of the workforce, who needs to re-enter. Let's talk about how we can do that in a comfortable way for both sides. Another advantage for mediation is that it really lessens the stress and the psychological harm to children. Kids just get caught in the crossfire a lot in their parents' disputes. And custody cases, when you go to trial, and I was a guardian ad litem where I represented kids in high conflict divorce cases and abuse and neglect cases, and parents grossly underestimate how much children are affected by parents' conflicts. Kids know what's going on. They can sense things. A lot of times parents are indiscreet and start talking about the other parent. Sometimes people call kids as witnesses in hearings, which is something judges don't like, but that judges can't tell somebody they cannot call a witness. So kids can really get dinged up, and there's a lot of studies now on the effect of conflict, the high conflict on kids, and the effects that it can have long term and short term for kids. It also avoids divorce mediation also avoids the expense and stress of litigation, and in terms of it is the average divorce case lasts probably the better part of a year, and it just is very stressful, and a lot of people that show their stress in different ways, but they're going to show it. And a lot of that is on the uncertainty of turning over these important decisions to a third party, to a judge, to make these decisions for you, and as I was saying before, in a very structured environment. And again, mediation allows you informally to craft your own solutions instead of turning over these really important decisions like custody and support and property division to a virtual stranger to make these decisions for you, who may have a very different view of your situation, may have very different values than you. In terms of how long does the process take, every situation varies. I get asked that question several times a month of how long will this take? What drives the number of sessions is conflict between the parties. And so the parties are in control of that. So if you can have the same set of facts, the parties own a townhouse and one parent is a federal employee and one parent is a teacher or a stay-at-home parent, and you can have those same facts and same assets and same number of kids and all that, but have two different sets of parents or spouses where one set wants to work things out collaboratively, wants to go to mediation and generate options and work through the process, and you may have other people who just want to fight. So it varies, but my traditional answer is that it's 3 to 5 sessions. Each session lasts between 2 or 3 hours, but sometimes they're shorter, depending on where we are in the process. As far as credentials, what does it take to become a mediator? Most mediators in the Washington, D.C. area, especially in Northern Virginia, are lawyers. You technically don't have to be a lawyer, but over the last 10 years at least, the field has become, and I think this is a good thing, dominated by lawyer mediators who know the law. We get certified by the Virginia Supreme Court, and there's a variety of specialties in terms of what you can be credentialed to mediate. I am what's called CCF, Circuit Court Family, which is the highest family designation you can get. Other certifications are just in custody, but my certification, and most mediators, lawyer mediators, are certified in what's called CCF. In terms of becoming a mediator, we have to do a lot of classwork. I think it's at least 40 hours of classwork, and then after we do that, we have to have, I think it's now still 5 co-mediations, where we have to do 5 complete mediations with a mentor mediator, and we have to have at least 2 mentor mediators through the process, not in each session, but in order to be exposed to different mentors and different mediators, the requirement now is that we have to work with them. I know in my training, I actually had 3, because there were 3 people I really wanted to work with, and it was a great experience. And then every 2 years, we have to get re-credentialed. We have to have you have to have 10 continuing mediation credits and get recertified every 2 years. So the role of the mediator, just do a little deeper dive into this. Our main role really is to facilitate the discussion, to get people talking in a respectful manner, in a civil manner, in a productive manner. We are also there to help the parties generate options, but there are times when people get stuck, and we as mediators, based on our experience, can jump in and say, would it be helpful if I gave you some different resolutions other people came up with in a similar situation? And people are always happy to do that, because if they get stuck or they only have 1 or 2 options and they want other options, they're always happy to hear that. We can give legal information I can run child support guidelines. I can go over statutes, case law. As I said, I can go over, how other people in similar situations did things, but we cannot give legal advice. Even though I am a lawyer, we are a neutral third party. So we cannot say to one party, this is what you ought to do, or to the other party, this is what you ought to do. But we can give legal information. And a lot of the time, by telling people the legal information, it helps them make that decision that they need to make. As I said, we're also there to draft the agreement. And the agreement is the only thing that survives the mediation in terms of any document. I always think of it as, if you're an archaeologist, the only thing evidence you would have of the mediation is that agreement. So we really want to make sure that that agreement is drafted well. And the way I do things is, after we usually don't resolve everything in the first meeting, but I will draft the agreement after the first meeting and come up with what's been resolved so far, whether it was custody or child support or spousal support or property, whatever it is. And then we may have other issues like taxes and life insurance and things like that, or how we're going to care for the family pet. And I'll notate that we still need to discuss this so the parties can see the agreement, and not only does it embody what the resolutions are, it also lets them know, okay, this is what we need to cover still. I often highlight things in the agreement of, if people need to do homework, or we need to know when your term life insurance policy expires. We need to know when you started your pension with the federal government, because we need to just figure out how to divide things up. I'm often asked at the end of the process, when people sign the agreement, can you file a divorce for us? I cannot file the divorce since I am a neutral third party, but and divorce is technically an adversarial process. So the optics would be, I would be representing one person or the other in a situation where I was a neutral third party as the mediator. In terms of styles of mediation, there's basically two styles: facilitative and evaluative. Facilitative is the model we tend to stay in most often, and it's pretty much what people think about when they think about mediation. We sit, we talk, we work stuff out. The other is evaluative, where it's more of going over parties' strengths and weaknesses, and then there's the facilitative, evaluative, or hybrid model. Let me talk a little bit about the facilitative model. Essentially, it is basically structured to help the parties come up with a mutually agreeable resolution. The mediator asks a lot of questions, validates points of view, searches for interests behind positions where somebody says, well, this is my position. And then we go behind that and say, well, what's driving that? What are the things that are important to you that lead you to that position? And then we help people find ways to generate options and analyze or look at those options and make sure that they're appropriate. In facilitative model, we don't make recommendations. We don't give opinions if the case went to court, how things would go. We're there to help generate options for the parties and help them come up with their own agreement. The evaluative model is on the other end of the spectrum. It's basically modeled after settlement conferences that you have with a judge. In different counties, they may have a pretrial hearing or a pretrial meeting with the court, and they may go over things. You may have a judge that sits down with the parties back in judges' chambers, where the judge tries to say, well, look, if I were deciding this case today, which I'm not because it's a settlement conference, this is what's important to me, or this is how I might rule. In an evaluative model, the mediator is basically helping the parties reach a resolution by going over the relative strengths and weaknesses of their cases and saying what would happen if the case were litigated, giving a range of outcomes. We're looking at legal rights. We're not looking at what's important to a party or what's driving a position. We're just saying, what is your right, and what is the likelihood that you would be successful in getting what you want in court. We also, in evaluative mediation, look at cost versus benefit of saying, okay, you want to get $100 more in support or pay $100 less in support. How much is that going to cost you? What are your risks if you go to court? And then we can also go over the law of looking at statutes and case law, but also then applying it to the situation. The hybrid model is a blending where you may start out in the facilitative approach, but you might get stuck on an issue. You might get stuck on custody. You might get stuck on spousal support. And then, one of the parties may ask the mediator to be evaluative, or the mediator may offer up, would it be helpful if I were evaluative? And if they are, then we go into the evaluative model and say, okay, we've worked out all these issues by in the facilitated model. We're stuck on this one issue. Let me switch over to the evaluative style. And I'm going to tell you what, your strengths and weaknesses are. If you walked into a courtroom, tell you what the, in my opinion, what the likely outcome would be. So it really is, you can mix and match on that. Mediation is a confidential process. A lot of people will say, what happens in the unlikely event we end up in a courtroom? Can somebody say what happened in mediation? And the answer is no, they can't. There are some minor exceptions, but mediation is a confidential process, and it is that way so that people can feel comfortable talking without worrying that somebody's going to, say or ask them in a courtroom or in a deposition, isn't it true you said this when you were in mediation, or didn't you agree to that in mediation? So people don't have to worry if that's going to happen. You can explore all the options you can. You can make offers in mediation without worrying that it's not going to, whether it's going to be used against you. It's not. And judges, as a practical matter, are very protective of the mediation process. A lot of judges feel uncomfortable in family law cases, and often they will say that on the bench. And I've had a lot of judges tell me off the bench, where they're trying to get years worth of information, sometimes decades worth of information, in a matter of hours. And they're trying to get all of this, and they have to make a lot of decisions in certain cases. It's not like a breach of contract case where, it's a very short set of facts. What was there a breach? What are the damages? It's not like a criminal case where, again, it's a short set of facts and then sentencing. A divorce case or a family law case, if it goes to court, a judge may be deciding child support, spousal support, property distribution. I've had cases where the judge had to determine the validity of the marriage. Is this even a valid marriage? And there's attorney's fees. Sometimes they have to take in, a lot of information about taxes or business valuation, depending on the situation. And they are much happier if you, who have all this knowledge, make these decisions for you, so that they don't have to make it, that you make the decision, for yourself, so they don't have to make it for you. There are a couple of reasonable exceptions to confidentiality. Family law mediators are mandatory reporters of child abuse, like doctors and nurses and teachers and school counselors. So if I seriously believe a child's being abused or neglected, I would have to report that as a mandatory reporter. Another exception is if I seriously believe one party's going to hurt the other, and others if I seriously believe somebody's going to commit a crime. But these are all pretty unusual exceptions. And so it is very rare that anybody would ever have to exercise them. So preparing for mediation is really important. The process goes much smoother, much faster if people come into mediation prepared. Sometimes people will have consulted a lawyer before they come in. It is important to have a lawyer in the process. The Virginia Supreme Court and I both strongly urge that. How you use your lawyer is up to you. Some people will stay in contact with their lawyer throughout the mediation process. Sometimes people come into the mediation process having already met with their lawyer, and then they'll just track with them throughout. Other people say, I'll find a lawyer closer to the end of the process when the agreement is more ready for signature, because I'm comfortable doing that, but I'll show it to a lawyer before I sign it to make sure that I'm not making any mistakes here. However you use your lawyer is completely up to you. It is important to consult counsel. It's also important to consult other experts. A lot of people need financial advisors. I know Argent Bridge is sponsoring this. I worked with them for a lot of years. I've only had good reports back from clients on them. because a lot of clients, there may be a division of labor in the house where one parent may be taking care of all the financial matters and the other person is busy with other things. But when a divorce occurs, there needs to be some leveling out of knowledge where, okay, maybe somebody has superior financial knowledge and they were handling it all, but the other person needs to know, what do we have? What are our assets? What are our debts? And then be able to understand what they are and consult an advisor so they're making good decisions. Should I trade the house for the pension? Should I buy out the other person? How do I do that? Do I need to get a mortgage? How do I qualify for a mortgage, etc.? Then there are tax experts. A lot of times, again, you may have one person that was handling all the taxes in the family, and now they're going to be filing single returns. Each party is going to be filing their own return. What's the best way of doing that? And also things like people may have rental property, and the property may have been depreciated, or they may have a lot of assets in a brokerage account, a lot of investments, and have their capital gains or their capital losses. What should I buy? What should I sell? Are we allocated properly in our investments? A lot of times people in going through the divorce process may be selling or buying a house. So talking with real estate agents or brokers is a good idea. And then mental health professionals, whether it's for yourself or to help your kids get through a divorce if they're showing some wear and tear. What we do when I mediate is I need financial information. So one of the ways we help people prepare for that first mediation session is to have them fill out a financial summary. And we have the web address for that, which is just www.novafamilylaw.com. And then we have a forms button, and under there is our financial summary that people can use. And so that it's helpful if people do that before they come in at their own leisure. A lot of times, people that don't do that, and then we're trying to fill that form out in session where I'm charging somebody to do that, and they're on their phone and they're trying to remember usernames and passwords, and then they get locked out and because they keep guessing wrong. So it can be a frustrating process. Much better if you come to mediation with that form prepared. I often get asked, if we mediate all of our issues, do we still need to go to court? And the answer is no, you don't. If you work out all of your issues, it becomes uncontested. You don't have a contested hearing, so you will never see the inside of a courtroom. But one of the things that is done in the process is that the agreement that we've come up with will be incorporated into an order of the court. So if you're getting divorced and you have a marital settlement agreement, part of the process is that, and it's a legal fiction, but it carries a lot of weight, which is the marital settlement agreement is incorporated into the final order. So not only is it an agreement, but now it's a court order. So if you violate the agreement, you violated a court order, and you're subject to the contempt powers of the court. And as I said before, that could be just getting a tongue lashing by the judge, to, in really bad cases, incarceration. So the agreement has a lot of teeth to it. But once you have signed that agreement, the actual divorce process is fairly administrative. The lawyers are just filing the complaint for divorce, getting it through the court system, getting the final order entered. They may be entering retirement orders, whether it's for a 401k, an IRA, thrift savings plan, a pension, whatever. Those are also entered to get the retirement assets moved. But it is a fairly administrative process once the agreement is signed. Do I still need a lawyer? As I said before, a mediator cannot give legal advice. We can give legal information. And mediation is not a substitute for receiving independent legal advice. A lot of times people will say to me, I'm not sure I'm going to get a lawyer, Brian. You've been doing this a long time. I trust you. That's great that you trust me, but I don't represent you. And so it is important, even if it's a 1 or 2 hour consult where you've just talked to a lawyer and made sure that you're making good decisions, because these agreements touch a lot of areas and almost all areas of your life. of, your children, your finances, taxes, life insurance, health insurance. You want to make sure that you're not making a mistake on any of those, and that the agreement says what you want it to say. But having said all that, a lawyer's involvement is a very small fraction in mediation as compared to litigation. So as much as people may not love the idea of, oh, I've got to hire a lawyer to review the agreement, compare that to, I'm going to have a 1 or 2 year relationship with a lawyer and get monthly bills if we go in litigation. In terms of if you need to terminate, or you feel like mediation is not working, or I have cases where people weren't happy with a particular mediator and then they changed and they came to me. And so you can terminate mediation whenever you want. It is a completely voluntary process from beginning to end. So for any reason, for no reason, if you don't want to continue in mediation, we're done. It can be a bit of an uncomfortable process at times. I do warn people that, that it can be uncomfortable. I do my best to make it a smooth process as possible. I'm very aware that it is uncomfortable for people at times. So we try to make it smooth. But if for whatever reason you don't feel like this is the right fit for you, whether it's the mediator or the process itself, it's voluntary, and you just terminate the mediation, and you're done. And people need to understand that is, I have some people who have said, well, I want binding mediation. Well, there's no such thing as binding mediation. Those are two very different concepts. In terms of costs of mediators vary. I'm a big believer in mediation, so I try to keep my hourly rate fairly low, or low reasonable. And my hourly rate is $3.90 per hour. That's total, that's not per party. Sometimes people say, is that $3.90 each? No, it's not. That's $3.90 per hour for both parties. And the way I do it is a pay-as-you-go model. I do not take a retainer. So it's a less financially complicated situation, and you just pay as you go in terms of each session or how long it's going to take to draft the agreement. And that is the end of my presentation. And if you have any information, or if you need any information or have any questions, feel free to reach out to me. I'm more than happy to have a 10 or 15-minute introductory call with people to inform them more about the process.
Thank you, Brian, so much for sharing everything today. And I know that you did touch on the fact that mediators do not by law have to be attorneys, but at Done with Divorce, we definitely want to encourage people to seek out an attorney who's also a mediator and vice versa, because we know that this agreement and this draft is going to be written, and it's going to be something that you are referring to for the rest of your life on most cases, and we want to make sure that it's a well drafted document. So, and then lastly, I know that at your firm that you require people to work with their own counsel, but that's not always the case. So there's some mediators that don't require that. And again, we just want to make sure that everyone knows that we encourage people to seek out their own counsel.
And I just to add on to that for a second. I mean, there are times when people don't want to seek out a lawyer. So we I'm okay with that. It's not great. But if somebody in the process says, I think this is simple enough, I don't want to consult a lawyer, I know you would like me to, but I don't want to, we still continue on, but we just strongly encourage people to have counsel.
Yeah, absolutely. So, all right. Thank you so much.
Okay.